contempt. Where is the opposite party?
So ज़्यादा was it?
वो 2:30 बजे वाला ज़माना अब खत्म हो गया।
हाँ, सुबह 2 बजे। इसलिए तो सुबह 2 बजे हो रहा 2:17 का आ गया।
Our chief is very particular about timings.
जी।
You have to follow it, and otherwise also we have to follow it. आने दीजिए। उनके एब्सेंस में ऑर्डर करना। वो मिला मुरारी भगत का ऑर्डर? देखिए। हमारे ऑफिस को नहीं मिलता, आप लोग को मिल जाता। इस नंबर को नोट कर लीजिए।
नेट में है।
नेट में तो है, लेकिन खोजने वाला भी तो चाहिए। हाँ, ये वाला जो है ना, फॉर्म वाला, हाँ, यही चीज़ हम खोज रहे हैं। चलिए ठीक है, आने दीजिए, आज करते हैं कुछ। उससे बहुत माइल्ड जज है, कुछ नहीं करना।
नो।
Item 421 contents to 949 of 1024.
Yes.
Lordship, on the last occasion, Your Lordship, petitioner was directed to furnish the document and to send that document to the university, Your Lordship. Your Ladyship.
They are fighting that.
They have had. Now the university has to take steps, Your Lordship. I am appealing for JPSC also, Your Ladyship.
देखिए, nobody appears on behalf of the petitioner. Are you there?
Yes, Lordship. For 20 serial number.
Sorry.
Hearing on behalf of the petitioner, Your Lordship. They frame for only 1 week's time because Mr. Lester has to appear on this case and he has put them on hand.
It is not required. Okay. Counsel for the petitioner and
JPSC.
JPSC are present. The learned counsel for the opposite party, JPSC, has submitted that a supplementary affidavit has been filed on behalf of the petitioners dated 25/7/2025, and now it is for the university to take necessary steps. Counsel for the university is absent. However, let this matter be adjourned. However, this matter is adjourned and is directed to be posted on 19th of September. The university is directed to do the needful and pass appropriate and file appropriate affidavit, so that the order of this court is complied in letter and spirit. आपके पास आएगा तो आप in case the university forwards the recommendation to the JPSC, the GPSC shall also do the needful prior to the next date and file appropriate affidavit. Yes,
I am appearing for the university edition.
they have filed a supplementary affidavit.
And they have filed, but they had to fill the prescribed pro forma in our format.
ये किसका फॉर्मेट है?
Vinova,
आपका कौन सा फॉर्मेट? Where is your
Vinod
format?
Bihari में तो कोई
आप ला के दीजिए ना फॉर्मेट. ये फॉर्मेट का कितना
कॉलेज
time?
यूनिवर्सिटी
कोई बात नहीं, आप हमको दे दीजिए, हम इनको दे दीजिए. ये कहानी मत सुनाइए, ये फॉर्मेट को. Show me the format. Where is the format?
format is available.
No, you give it to me. I don't know the format. Give me the format.
एक लिखित बस एक बार जो इनका सप्लीमेंट्री हो गया.
हम देख लें. उन्होंने कुछ फॉर्म भरा है.
हाँ.
अब आप बोलते हैं उनका फॉर्मेट है, इनका फॉर्मेट है, आपकी
फॉर्मेट बस इतना ऊपर विनोबा भावे लिखा हुआ है और उसको हमारे तरफ से स्क्रीन करके भेजना होता है जेपीएससी को.
Yes.
नीचे हमारा सर्टिफिकेशन होता है तो
You
सर्टिफिकेशन हैज
just
टू
you
बी डन
say that this is not in the proper format.
करेक्ट.
This is Vinova Bhave University. नहीं होना चाहिए. किस में होना चाहिए?
विनोद बिहारी में तो कोयलांचल यूनिवर्सिटी.
ये विनोबा भावे यूनिवर्सिटी. बाकी रेस्ट इज द सेम.
जो डॉक्यूमेंट्स लगे वो लगा देंगे.
डॉक्यूमेंट्स नहीं, ये फॉर्मेट में सब चीज वही है. आप हमको एक फॉर्मेट, उनको फॉर्मेट दे दीजिए. समझ गए? Take it again. The counsel for the parties are present. A second supplementary affidavit has been filed on behalf of the petitioners, who has submitted that the entire matter has now been submitted in the prescribed format. However, counsel for the opposite party university
यूनिवर्सिटी बीबीएमके यूनिवर्सिटी ऑपोजिट पार्टी नंबर 5 and 6.
opposite party number 5 and 6 has submitted that the format is not proper in as much as it is in the format of Vinod, it is addressed to Vinova Bhave University in Zaribagh, and even as per paragraph 5 of the affidavit, the format is to be the documents with the in prescribed form has to be deposited before Vinod Bihari Mehto University at Dhanbad. The council undertakes to provide the prescribed format to the council for the petitioner within 1 week. Soft copy चाहे कैसे भी forward कर दीजिए. उसका print निकाल के वो fresh डाल दीजिए. Council for the petitioner seeks adjournment. बीच में आ जाएगा ना तो कर लेंगे इसको. हम इसको 19 सितंबर को रखें. Post on 19 September. In the meantime, the petitioner may submit in the prescribed format to the concerned university, and it is expected that needful will be done prior to the next date.
Item 422, CMP 972/2024.
This is for restoration of WBS number 4654 registered rejected due to non-compliance of preemptive order measures.
CAP number 972 of 2024. This petition has been filed for restoration of WPS number 4654 of 23, which stood dismissed for non-prosecution on account of non-removal of defects in terms of order dated 13/5/2024. The learned counsel for the petitioner has submitted that the defects could not be removed in spite of best of efforts, and he submits that the writ petition be restored, and he undertakes to remove the defects upon restoration of the writ petition. Counsel for the opposite party, any objection? Has no objection to the prayer for restoration. Considering the aforesaid circumstances, the time for removal of defect granted to the petitioner wide order dated 13/5/2024 in WPS number 4654 of 2023 is extended till 29th of August. If the defects are removed in the petition as per the stipulated time, office is directed to post the petition before appropriate bench as per roster. CMP is accordingly disposed of. It continues to be preemptive.
Item 4 and 23, CRMP 1052 of 2024.
Yes, please. Why do you need a passover?
आ रहे होंगे खाली पासवर्ड
तो अभी क्या ही करने वाले हैं? अभी तो पहली बार डिस्कवर ये क्या ऑर्डर्स हैं? Restoration, criminal revision, लाइए तो criminal revision का रिकॉर्ड लिखा Yes, you wait a second.
दो केस के लिए पासवर्ड किया जाए
कौन बहस कर रहा
चार चार
Item 4 and 24, Contempt Civil 46 of 2025.
Lordship, in this case, 3 weeks time may be granted for filing compliance order.
State was directed to file a complaint.
3 weeks में हो जाएगा?
3 weeks time may be granted for filing
आप
compliance
इनकी तरफ से
OP number 2.
OP number 2 has to file a compliance report.
नहीं हम हाँ पेमेंट तो हम ही को करना तो हम ही फाइल कर देंगे कंप्लाइंस चलो फाइनेंस में भेजे थे तो फाइनेंस को वापस भेज दिया कि डिपार्टमेंट के थ्रू भेजने तो हम लोग सारा प्रोसेस कर रहे हैं हम लोग विद इन 3 weeks इनको पेमेंट कर देंगे 3 weeks का प्रेयर कर रहे थे
Contempt case civil number 46 of 2025. Counsel for the parties are present. Counsel for the opposite party number 2 pays for 3 weeks time to file a compliance report. We have submitted that on account of certain procedural error, the order could not be complied. Post on 29th August. The compliance report should be filed by 27th of August.
Item 4 and 25, Civil Review 75 of 2025.
Lordship, I have filed this review application against impugned order dated 7/3/25, passed the first appeal number 43 of 2012. Lord, my simple prayer is that I have been deleted. My name is deleted from the cause title of the second appeal, from the appeal 43. Right. But what has happened, my plots are there. My 3 plots are there in the schedule. So if that will be deleted, matter is. I have got no grievance. My simple prayer is that.
Which all are the 3 plots?
That plot, sir, 615, 603, 604, and 605, 84. Sorry, sir. 603, 604, and 584. 58. And this is as per
Where is the-
impugned order,
Where is
paragraph
the
5.
para number?
Para number 5 of the impugned order. I would like to read, madam. Learned Counsel for the respondent number 1 to 9 has also submitted that an
You are
affidavit.
respondent number 1 to 9?
No,
We were respondent number 23
we are respondent 23.
in that first.
In that first step.
Where is your submission so far as respondent number 23 is concerned?
My submission in the impugned order.
Yes.
My submission in impugned order, Lord, you find at paragraph 8. 9 also there. But what of the undertaking? That is most important, which has been incorporated in paragraph 5. I would like to read you verbatim. Learned Counsel for the respondent number 1 to 9 has also submitted that an affidavit has been filed in the case on 6/3/25 and specific statement has been made in paragraph 13 and 14 of the said affidavit that the original plaintiff do not wish to proceed against Messrs. Ashrafi Hospital Limited in the execution case to the extent it relates to a transfer of property 11.92 acres by release date. So 11.92 acres has not been deleted in terms of the plots, 3 plots. So if these 3 plots will be deleted, that much, nothing more than that.
Yes.
Civil review number 75 of 2025. All
Yeah,
the lawyer
answer to
counsel
it.
appearing on nothing. I know.
Even
It is that it is simply
why?
that you will not execute.
Absolutely. I have already filed a separate suit, and your lordship,
जरूरत नहीं है,
I'll
आप
just
क्यों अपना
clarify.
दिमाग ला-
I
I'm not
know,
going to
I
review
know,
this
I know.
order.
Therefore, I say, now your lordship strangely he wants deletion from the suit property. Then what would happen? My claim against Datta's would also go.
How can
वो
that
सब
be done?
नहीं वैसा कुछ
I've
नहीं है।
already filed a separate suit against them.
I was reading your submission also. That is quoted in the
We
order.
have already filed a separate suit.
Civil Review number 75 of 2025. The learned counsel for the petitioner. This petition has been filed seeking review of order number 85 dated 7/3/2025, passed in first appeal number 43 of 2012. Whereby आप 23 थे कि 21? You have said 21.
After deletion, I became 20. 1 to 21. Earlier?
Okay. Whereby the
20. Earlier
petitioner
20.
was respondent number 21 in petitioner was respondent number 21, namely Asharfi Hospital Limited. He submits that at the relevant point of time, the present petitioner Asharfi Hospital was respondent number 23. The learned counsel submits that this petition has been filed in view of the undertaking given by respondent number 1 to 19, who are the original plaintiff.
1 to 9.
1 to 9, who were the original plaintiff and were respondent in the first appeal, who stated that they did not wish to proceed against Messrs. Asharfi Hospital in the execution case to the extent it relates to transfer of property of 11.92 acres by lease deed. The learned counsel submits that the property comprising of 11.92 acres was in relation to Khata number 603, 604 and 584.
Plot number.
Sorry,
603.
plot number 603, 604 and 584, and he has also submitted that this property should be deleted from the adjudication of the first appeal, so that no list in connection with this property is ultimately decided in the first appeal. The counsel for the plaintiff has appeared suo motu. You have entered appearance?
Yes, yes.
Has appeared suo motu, although no notice was issued in this case, and has opposed the prayer. He has submitted that the undertaking was that they would not proceed in the execution case arising out of the judgment and decree passed in the first appeal
Against them.
against Asharfi Hospital,
And we have
to
already.
the extent of transfer of property of 11.92
Nine,
acres. He submits that the entire undertaking in paragraph 12 to 15 of the affidavit dated 6/3/2005 has been recorded in the order under review. He has also submitted that the petitioner herein is fighting a separate suit.
We have already instituted a separate suit.
He has also submitted that the respondent herein,
Yes, 1 to 9.
who were plaintiff in the suit, in the earlier suit, has already filed a civil suit against the present petitioner,
Yes.
which is pending,
And, yes, and state of mind.
in which state is also a party.
Yes.
The learned counsel has also submitted, after hearing the learned counsel for the petitioner and the respondent number 1 to 9, who were the plaintiffs in the earlier suit, which is subject matter of first appeal number 43 of 2012. This court is of the view that this court finds that, as recorded in the order itself, the plaintiffs who are respondent in the first appeal had only undertaken not to proceed in the execution case, and the petitioner hearing had filed an interlocutory application before this court in the first appeal, seeking remand to the learned trial court as they were never a party before the learned trial court. The fact remains that final hearing in the first appeal has already concluded and the judgment is reserved. In view of the aforesaid facts and circumstances, no grounds for review of the order dated 7/3/2025 has been made out. The present petitioner is no longer a party in first appeal number 43 of 2012, and the first appeal is to be decided on its own merit. This review petition is dismissed.
And on the point that clause should be deleted therefrom. Otherwise, the condition is same.
चलिए कोई बात नहीं. आपको जो बोलना है अपने सूट का written statement फाइल करके बोलिए. This decree will not bind you.
And I will find my.
Strangely, you have sought a
This
recovery
decree-
of possession from him. in a
This
separate
decree will
My-
not bind you.
Lord, but in that my woman part has been recovered by taken over by them. That is the problem, and I am not getting loan from the bank itself.
You will not.
Actually, they are not saying, but after
Item
11.92,
So I
they are in
find my-
possession of 18 acres, approximately 6 acres each. So this
आप
they are
चिंता
not.
मत करिए. First appeal जल्दी ही decide होगा.
Let
ज़्यादा time
it
नहीं
be
लगेगा.
decided in the first appeal also. So,
Sorry?
but the fate of the plot is concerned that it come unless that be
First
deleted.
appeal के बारे में हम यहाँ पे क्या बोल सकते हैं? आप पार्टी नहीं है उसमें. Yes,
But my plots are there, na. If I am not there, my plots are there.
You are there to
That is
advise
okay.
your client. ऐसा काम मत करिए. Please don't do this.
Or my problem let be hard.
I know.
Compassionately that I am not getting any loan.
लोन आपको नहीं मिल रहा है तो यहाँ से मैंडेमस थोड़ी इशू हो जाएगा. Yes, madam.
The leadership order is not been complied with.
Yes.
The requirement was to
Otherwise
give
complied
first,
with.
second and third MSCP was supposed to be given to the petitioner.
Why are you not complying with the order?
Otherwise, fully complied with.
Fully complied.
Let
क्या
me
किया
kindly
आपने?
see the reason order.
Direction
what
was
they
to
have stated.
pass the reason order, Lordship.
And what happened?
And we have passed the reason order after hearing the petitioner, and we have also paid the admitted dues.
It has not. Your Lordship, kindly see what was the prayer made in the writ petition.
Yes. Let's see.
Number one, for a direction upon the
तो
respondent.
पिछली बार हम लोग देखे थे. 7th पे कमीशन दे दिए.
Sir, none of the employee of the Nagar Parishad was given the 7th pay commission.
कहाँ से बोल?
Lordship, from the reason order, Lordship. Kindly come to.
They are stating in the
my-
reason order, Your Lordship, that others are not getting, therefore I will also not get. And
But
the
there was a
depart-
direction to give 7th pay
No, no,
commission,
no,
or it was
no,
a
no.
direction to consider your representation.
Director
Consider
consider the
after,
representation.
after giving opportunity of hearing to the petition.
That's
So, Ladyship, twice they have filed the supplementary affidavit directing the reason order. Both the reason orders are exactly same, Ladyship. If you Ladyship will kindly.
Yes, both the reason
No,
order.
the reason order has also been passed in connection with 7th pay commission.
Yes, ladies. Kindly come
Ladyship, you kindly
to.
see the order. It is at page 8, Annexure 1.
They must have passed the order pursuant to the order of this court. Where is that order?
Kindly see,
Order is at
page
my
8, Your Ladyship.
supplementary counter affidavit filed on 16/6/2025. 16/6/2020. My last supplementary counter.
Order.
affidavit. Orders.
Order is at page 8, Your Ladyship.
नहीं, वो नहीं पूछ रही.
High Court's order.
The learned counsel for the petition submits that in terms of order, an order was to be passed.
Order is
after granting an
annexed C
opportunity
at
of
page
hearing.
19 of my last supplementary.
You see, you were not heard, as recorded in this order dated 16/4/2025. Thereafter, did they hear you and pass an order?
Yes.
Exactly the same order.
Maybe they can
After
repeat the
seeing
same
this
order.
order, Your Ladyship had
After
again
hearing
directed
after
them.
hearing
No,
the petition.
Again,
See,
Your
just-
Ladyship had directed them to pass a fresh order.
First, we asked them to pass an order on 16/4/2025 after hearing it. Thereafter, another order was passed.
Yes, ladies.
Exactly same, Your Ladyship.
There was
Yes,
thereafter
they
by
have
this
passed.
court another order was
Another
passed.
order has been passed.
Which order is that? There is
That
no
is
such
annexed
order.
annexed
The
C.
second
अरे भाई
supplementary.
हमारे ऑर्डर का बताएंगे ना, आप समझ नहीं रहे. Initially they passed an order where you said that you were not, right?
Yes.
Thereafter, we asked it to hear you and pass. Right? There is an order to that effect.
Yes.
They have heard you and passed a fresh one.
Yes.
They have repeated the same thing.
Yes.
Right? There is no legal bar. They can repeat the same thing. They can repeat the same reason after hearing you also. Right? They have done it. And उसके बाद क्या करें हम लोग? आपका 7th पे रिवीजन नहीं मिला है. You have to in the content you have to show me that I have issued a direction to give you 7th pay. There is no such direction.
One more thing, Your Ladyship. The first prayer was that for a direction upon respondent number 3 to pay 30% of 21 months arrears of salary as per the 6th pay commission with interest. They have paid this but without interest, Your Ladyship.
You have not paid the interest.
And they have not given any reason in the reasoned order that why they are not paying the interest.
Kindly
They are not
come to the
business
rejoinder filed by the petitioner. In that they have admitted that they have received their
Interest.
Lordship, in para 17, I may be permitted to read. No, para 15.
Para 16, Your
That's,
Ladyship, kindly
that's
see.
only 30% of the 21 month salary as per the 6th pay commission with interest was paid to the petitioner, and thereafter
This
nothing
is
has been paid.
without interest, Your Ladyship. This
As
is
it is also
typical error.
आपका
In the next
typographical-
paragraph, Your Ladyship, may kindly see that there was a direction upon the opposite parties to consider the case of the petitioner for payment of first, second, and third MSP benefits by pay fixation and to pay the arrears, that is difference of salary to the petitioner with interest, which is not being paid by the opposite party. I stated
That
clearly
was
in
only
para
the
16.
prayer
Your
of the
Ladyship.
prayer. There was no direction to pay interest.
No, but once you have paid that amount, then interest must be paid, Your Ladyship.
Without direction, how we can pay interest?
Was a direction for making payment of interest.
Direction was to consider and pay. But once you have paid, then the interest must also be paid. And if you are not paying the interest, then reasons must have been assigned there that why you are not paying the interest.
Is it your statutory interest?
No.
Your Ladyship, there
It
was
is the area of the salary.
Statutory interest होगा तो they are bound to pay.
No, there is no
Your
statutory
Ladyship
interest.
had only directed that the interest.
So I just want to know, is there any direction by this court to pay interest?
No,
Show
no.
me that.
After para 6, Your Ladyship, page 8, if you Ladyship
Yes,
kindly
yes.
sees.
Yes.
Upon filing of such representation, the respondent number 3 is directed to consider the grievance of the petitioner and pass a reasoned order after verifying the records and granting an opportunity of hearing to the petitioner or her authorized representative. The reasoned order be passed within a period of 4 weeks from the date of representation and be communicated to the petitioner through speed post if the petitioner is entitled to any monetary benefit out of the reasoned order. Appropriate steps be taken by the respondent number 3 so that the amount be remitted to the petitioner directly in her bank account, whose details are also provided by the petitioner representative that needful must be done, verifying the
ऐसा कोई
identity of
direction
the
नहीं है, madam.
petitioner as such.
Content has a very limited jurisdiction. I have not given them any direction to make the payment. There is no statutory interest assigned to this particular amount.
What
If
I'm
you
saying
want to
is
have
that
any
in the
more-
prayer only, Your Ladyship, it was there.
Prayer is not the mandamus. You are supposed to pray the sky, but whatever is entitled. हम ऐसा भी ऑर्डर करते हैं, अगर इस टाइम में नहीं मिलेगा तो इतना इंटरेस्ट देना है, लेकिन वैसा भी कोई डिफॉल्ट क्लॉज नहीं मिलते ऑर्डर में, इसमें है ना. कभी कभी होता है ऑर्डर में डिफॉल्ट क्लॉज that if they do not pay within 6 months, they will have to pay interest right from the date of the payment. ऐसा भी ऑर्डर करते हैं, ऐसा नहीं. लेकिन आपने वैसा कोई ऑर्डर मांगा नहीं, इसलिए नहीं मांगा. Content case civil number 171 of 2025. The learned counsel for the parties are present. This petition has been filed for initiating a contempt proceeding against opposite parties for their alleged willful and deliberate non-compliance of the order dated 20/2/2024 passed by this court in WPS number 7619 of 2023. The records of this case reveal that one show cause was filed annexing a reasoned order. However, on 16/4/2025, it was submitted that the reasoned order was passed without giving an opportunity of hearing to the petitioner, and subsequently the petitioner was heard and a fresh reasoned order has been passed. The learned counsel submits that the same order has been practically repeated. She has submitted that no relief has been granted so far as 7th pay revision is concerned, and interest on the admitted amount has also not been paid. She has referred to the prayer made in the writ petition, which has been quoted in the order dated 20/2/2024, passed in WPS number 7619 of 2023. The learned counsel for the opposite party, while opposing the prayer, has submitted that the order of this court has been complied in letter and spirit. He has also submitted that the reasoned order has been passed and there was no such direction to give one or the other benefit to the petitioner. He has submitted that if the petitioner is aggrieved by the reasoned order, she can take appropriate steps, but so far as the compliance of the order is concerned, that has been done. Though belatedly, thoda late hua. After hearing the counsel for the parties and considering the nature of the order passed in the writ petition, this court is not inclined to proceed any further in this contempt petition. However, liberty is reserved with the petitioner to take steps in connection with the reasoned order as may be permissible under law. The contempt proceeding is open.
Item 4 and 27 contains till 451 of 2025.
Order complied with law. This is the matter pertaining to the president appointment. And we
Content Civil 451 of 2025. Counsel for the parties have present. The learned counsel for the opposite party has submitted that the order has been complied.
yes, Lordship, we will
उनको
take
दिया है कि रिजेक्ट कर दिया?
reject it. Para 7 of Sokos and the annexure B by 1 Lordship. Case 41.
The council has submitted that reasoned order has been passed with the press release.
Case 31, annexure B by 1, column 2.
Where is the consideration of the order passed in WPC number 3894 of 2021? Reasoned order में दिखाइए. Because the order clearly reveals that this particular judgment is required to be considered. Reasoned order में दिखाइए that this judgment has been considered. Yes, tell us. Read the reasoned order.
Your Lordship, they have only 2 lines. They have stated that the particular reason certificate that has been issued by the unrecognized institution. Because of that, the compassionate appointment has been rejected. Claim of the petitioner.
ये जो order है,
Yes, Lordship, I have
read
seen
का
that.
order.
Yes,
इस
Lordship,
order
para
का
7
consideration कहाँ है?
Para 7, 8, 9.
ये बहस तो कुछ नहीं की, लेकिन इनकी शक्ल से हमको पता चल गया कि कुछ गड़बड़ चल रहा है, इनको समझ नहीं आ रहा है क्या।
रिजॉइंडर ये फाइल की होगी.
हमको रिजॉइंडर से मतलब नहीं है मैडम. You are in contempt jurisdiction. You show the compliance of this order. Nor we are concerned with the petitioner. बताइए आप हमको, where is the consideration of this order of the court? WPS number 3894 of 2021.
उसके बारे में स्पेसिफिक नहीं भी होगी.
Specific क्या कुछ नहीं लिखे हैं? There is no reference.
Next week के Lordship.
We are here only to pass orders, and you will not even look at the order.
I have seen para 7.
So, para 7-8 में भी तो है.
जी जी para 7 नहीं.
Then,
Para 7 onwards.
where is it? Where is the consideration of this order?
They are para 8.
The counsel for the opposite party has submitted that reasoned order has been placed on record. However, the reasoned order does not reflect consideration of the order passed in WPC number 3894 of 2021, which was specifically referred to in the order dated 23/4/2024 passed in WPS number 6091 of 2023. Counsel for the opposite party seeks adjournment. चलिए कब करना है? नेक्स्ट वीक क्या कंप्लाइंस फाइल कर देंगे, क्या करेंगे?
Why they have not done anything in this regard? For 2 weeks maximum.
Pose this case on 14th of August in the supplementary cause list. The learned counsel for the opposite party will produce the connected records relating to the reasoned order passed in the present case. अब record ही लेके आइए on the next date.
Item 428 contains civil 532 of 2025.
The order is not in compliance. Kindly see so-called OP number 2 and 3, page 6. Already university has been forwarded to JPSC.
What are you doing?
And thereafter, we have filed a show cause action. That is on record.
What happened?
There are certain discrepancies which was noted. Thereafter, they have sent a letter to the university concerned to clarify. Once that clarification is,
Where is the counsel for the university? There is one letter by Jharkhand Lok Sabha Seva.
they have already sent on 27th of July 2025. Annexure A.
Yes,
for
I
show
did.
cause. Yes, sir.
Only one letter to another letter being sent by
Yeah.
JPSC, but they are not granting promotion to me.
They are asking the university to produce a letter.
Yeah, they are asking because the proposals were sent but the columns were left blank. So there is the situation as to how why this was forwarded.
Who is the counsel for the university?
We
उनको भी
know
party
our
बनाया है. They are also party in this case.
Yeah, they are party.
They are not party.
They are party.
Where are they?
So,
Registrar. Is somebody appearing?
last time he was appeared. Amresh Kumar is appearing.
Who?
Amresh Kumar.
Manish Kumar. Where is
Amresh.
he?
Mr. Amresh.
Sorry?
Amresh Kumar.
Amresh Kumar. Amresh
So
Kumar.
just inform me.
Okay. Matter was sent to referee.
Yes.
There were two full threads. One was regarding the concurrence which we have already provided. Now once the proposal for promotion is signed by the university will act upon that. That is the only clarification which is required from that. So Lordship may post
Amresh Kumar कहाँ है?
I just informed him if Lordship says that this was the direction so that he can reply.
Already the university has forwarded to these all documents are missing.
Okay.
Kindly see my lord.
The learned counsel
Page
for the
6.
petitioner and JPSC.
Yeah.
And opposite party number 4. You are representing number 4
I am representing for
is present. Nobody appears on behalf of opposite party number 2 and 3. The learned counsel for the opposite party number 4 has submitted that a letter has been issued by DPSC which is dated 22/7/2025 to the university seeking certain documents. it is expected that the university would respond to the same at the earliest so that the order passed by this court is complied with in letter and spirit. ये एफिडेविट उनको सर्व किए हैं यूनिवर्सिटी को?
Yes, sir.
Yes, sir.
एक ही
Counsel
बार
for the opposite party number 4 has also submitted that a copy of the affidavit dated 26/7/2005, 25/7/2005 has been served in the office of the respondent university. Namely, Mr. Amresh Kumar,
He is to.
posed this case on 22nd of August. No, 29th of August.
डायरेक्शन दे दिया जाता कि फिर कोई लेटर नहीं भेजे, जो भी क्वेरी है वंस एक बार जो लेटर भेजें उसी में सब
And it is expected that in the meantime, the university shall do the needful. Since the counsel for the university is absent, office is directed to forward a copy of this order to opposite party number 2 and 3. यही लोग हैं, कोई और हैं आजकल?
नहीं
यही लोग हैं?
बस
Opposite party number 2 and 3. Through speed post. So we post on 29th first.
Item 429, CRNP 562 of 2025.
This was for restoration because the opposite party has been noticed because the draft had been handed over to him.
Okay.
Because he is appearing for the state.
He has not appeared. Opposite party अब नहीं appear कर रहे हैं.
तो पैसा ले लिया, draft उनको मिल चुका है. Service in the CMPs, the CRMP itself must have annexed the copy of the draft also. And the petition which was supposed to be filed over here, he had filed before the learned lower court.
कौन सा order था?
Because the order was dated 8/2/2024 minutes.
इसमें क्या order किया था?
Milords had directed that by 7/3/2024 minutes, the Milords, if the matter is compromised, suitable petition to the extent of Milords exemption from surrendering would be filed. Milords.
तो वहाँ पे सिर्फ draft file हुआ था कि compromise petition?
Compromise petition had also, but it was not accepted because by the time Milords, the court below had been functus officio to that extent. Milords.
अब तो वो आएंगे.
आ जाएंगे, बात हो गई है, एक डेट खाली आ जाएंगे, क्योंकि हमने पैसा दे दिया तो I had to arrange events.
At the request of the counsel for the petitioner and awaiting the appearance of opposite party, the matter is adjourned and is directed to proceed on 29th of August.
Okay. 29.
Item 430, item seal 506 of 2025.
Yes, please.
In this case, my lord, one opposite party was added as opposite party number 15. Notices were issued and that is validly served.
कौन से orders हैं? OP number 15. Is anybody appearing? कौन है OP number 15?
My lord, basically, my lord, that para 40, page number 60.
Executive officer नगर पंचायत.
My lord, and what was the direction? My lord will kindly come to page number 67.
Yes.
Page number 43, paragraph 40 is to be complied. So far as petitioners who are teachers of class 6 to 8 are concerned, the reason for pendency of required scrutiny of Lok Sabha election which is over and much time has elapsed, the concerned administrative and disciplinary authority are directed to expeditiously decide the matter regarding scrutiny of such teacher in terms of decision taken in second floor meeting in terms of service rule of 2021 within a period of 2 months from the date of communication of this order. Order was dated. So, order was dated 1st July 2024.
There is a council for JPC. आपने क्या हुआ?
Last time notice issue.
Notice was the properly served.
तो क्या करें? क्या करेंगे? क्या करेंगे? Senior is on the way. बुलाइए. वही खड़े होकर इसमें नोटिस कराए थे जहाँ तक हम लोग हैं. Right?
It is the look after of the state authorities to see that whether all members are participating. Tomorrow they will say that another person is not this court. What they want that this court shall run before every person. It is their responsibility.
Item 431, CMP 618 of 2025.
Sorry?
Praying for not.
Who is the arguing counsel?
सब उनके घर में कुछ मेडिकल इंश्योरेंस है ऐसे.
5,000 रुपये जमा हो गया? नहीं पता. दिखाइए तो इसका रिकॉर्ड. यहाँ पे जरा देखिए ऑफिस नोट में है आज the council has not received the memo. लेकिन कोई रिफ्यूजल नहीं है. यहाँ पे रिफ्यूज लिखना चाहिए ना, रिफ्यूज टू एक्सेप्ट, ऐसा कोई रिफ्यूजल नहीं है, ऑफिस को लिखना चाहिए। रिफ्यूज्ड, कोई आदमी जाता रिफ्यूज करते हो, और हम लोगों ने उनको सॉफ्ट कॉपी फॉरवर्ड करने का ऑर्डर किया। सॉफ्ट कॉपी कब फॉरवर्ड हुआ? 14/6 को अपलोड हुआ है। देखिए तो ये सॉफ्ट कॉपी क्या यही है फॉरवर्डिंग, देखिए और ये अपने पिटीशन में लिख रहे हैं इनको सॉफ्ट कॉपी 18/6 को ही फॉरवर्ड has been forwarded on 8/6/2025, was not able to contact the applicant and could not deposit the money as directed. सॉफ्ट कॉपी नहीं फॉरवर्ड हुआ, ये लिखा हुआ है ना, तब देखिए इसमें लिखे है कि इनको कॉपी फॉरवर्ड हुआ है। इनका इसमें जो है ना कुछ पैसा जमा कराना है, उसके नहीं जमा कराने के कारण इनका केस DFT हो गया। तो पिटीशन में ये एज रिटन दैट इट वाज सबमिटेड एट, हम रेस्टोर कर देते हैं ना, इसमें मंडे के लिए क्यों करना, कर देते हैं हम रेस्टोर। ये सेकंड अपील का रेस्टोरेशन दिखाइए तो नोटिस वोटिस हो क्या देखते हैं इसमें। नहीं हुआ था ना, CMP number 618 of 2025. Learned counsel for the petitioner is present. This petition has been filed for restoration of second appeal number 107 of 2023, which stood dismissed on 18/6/2025 due to non-compliance of order dated 12/6/2025. The petition reveals that the petition seeking restoration reveals that the soft copy of the order passed by this court was forwarded to the counsel for the appellant on 18/6/2025 at 3:48 p.m. Although the order to communicate the copy was passed on 12/6/2025. The records of the second appeal does not reveal as to when the order dated 12/6/2025 was complied by the office. Therefore, there is no reason to disbelieve the statement made in the petition seeking restoration. Considering the aforesaid facts and circumstances, the time for complying the order dated 12/6/2025 is regarding deposit of cost of ₹5,000 is extended till 22nd of August. If the order is complied within the extended time, office is directed to place the second appeal number 107 of 2023 before appropriate bench. This CLP is accordingly disposed of.
Item 432 CMP 065 of 2025.
his petition?
For modification of the judgment rendered on 24th of January 2025. What happened, the petitioner during the pendency of the petition, he already attained the age of superannuation on 30th September 2019. This fact could not be brought to the notice of the Supreme Court either by the other parties. And the case was pending since 2014. Therefore, the direction was given after setting aside the order of dismissal. The direction was given to restart the inquiry. This is just page para 14.
Yes.
Para 15 actually. Para
Yes.
15. Therefore, after retirement, the departmental proceeding.
No. Departmental proceeding
Then
will go
let
on.
them. That 6 months has already crossed.
We are not concerned. You are filed this modification on the ground.
In lieu of the service relationship between the employer and employee. It sees immediately after. There can be a proceeding that is under Rule 43B. There can be, but not a departmental proceeding. That is the law.
Reinstatement तो फिर आपका ये पूरा ही order recall कर देंगे.
Reinstatement हम मांग रहे हैं.
क्या है? Observe that the petition is
अगर
reinstated.
that is dependent upon.
As consequence of setting aside of the
That
order.
that is dependent upon.
No, that is not.
No, I have not made a prayer for reinstatement. It is my only
नहीं,
prayer.
आपका सिर्फ inquiry जो करना था वो only for the purposes of
Yes, inquiry.
conduct of inquiry.
But that my only prayer before Lordship, that the law says that departmental proceeding would cease on the date of superannuation. But
ऐसा
they
कोई law हम नहीं
can,
जानते.
they can convert.
अगर मान लीजिए कोई
They can
proceeding-
convert it into under Rule 43B. That
Yeah,
can be.
that will not
That is
modify
also a
this.
proceeding.
We do not.
I will.
That is-
I will satisfy.
You might have nothing to satisfy about it. You might have superannuated. Whatever be the consequences, it will follow.
But the
Whatever be the consequences, अगर आपको
departmental
लग
proceeding is not maintainable.
we do not know. You see, whatever be the consequences, उसके लिए आपको fresh sheet file करके अपना जो relief लेना है लीजिए.
नहीं,
ये order इसके लिए modify नहीं है.
डिपार्टमेंटल प्रोसीडिंग चलेगा इसके लिए हुजूर टाइम दिए 6 महीना and that has not been done that
तो
has
उसके लिए आप
I'm
fresh
not-
sheet
I'm
file
not
करिए
seeking
for your
such-
relief.
but my duty is not to inform this court that he already superannuated.
Maybe it's superannuated.
That is the only thing which I
That's right.
brought to the notice of
CAP
this.
number 665 of 2025. This council for the
Only
parties
proceeding
are
can be
present.
under Rule 43.
This
No other.
petition has been filed seeking modification of order dated 24/1/2025 passed in WPS number 564 of
568 of
568 of 2014. The learned counsel has submitted that
Para 24. Para 23.
has referred to paragraph 23 of this petition to submit that the writ petition was filed in the year 2014 while the petitioner was in service, but by the time the final order was passed, the petitioner had attained superannuation on 30/9/2019. He submits that this fact could not be brought to the notice of this court by both the parties. The learned
Yes,
counsel
it
has
is
submitted
clear.
that on account of superannuation, the disciplinary proceeding cannot continue. And therefore, he is seeking modification of this order. आप क्या support कर रहे हैं?
नहीं.
The learned counsel for the opposite party is opposing the prayer. Sir, आपका client बहुत smart. The learned counsel for the opposite
नहीं,
party और उसको बता दीजिएगा कि हम उससे ज़्यादा smart हैं.
नहीं स्मार्ट नहीं है हुजूर हमको अगर बोल दिया रहता तो हम उसी दिन
कोई बात नहीं. The learned counsel for
transfer brief
the
था.
कोई बात नहीं. The learned counsel for the opposite party has opposed the prayer
हुजूर का परमिशन
and
दिया
has
परमिशन
हाँ जी, and has submitted that merely because the petitioner has attained the age of superannuation on 30/9/2019, the order cannot be modified as the list commenced way back in the year 2014. Considering the aforesaid submissions, this court is not inclined to modify the order passed in WPS number 568 of 2014. इसमें LPA फाइल हुआ था ना? ऐसे सिल मत
नहीं देखिए इस फाइल को
बताइए, देखिए तो सर, इसमें आपको लगता है LPA फाइल हुआ था 568 of 2014, WPS 568 of 2014, dismissed. तो कॉल करिए.
Item 433, contains 737 of 2025.
Because the LPA was listed today itself, was at serial number 25. Because the Honorable Division Bench, without entering into the merits of the case, prima facie instructed us to convey to the client that the case of the petitioner should be looked sympathetically or compassionately.
You don't need any sympathy now.
What was stated by the division
The
bench?
majesty of law does not need any sympathy.
What was stated by the learned division bench, that is what I'm.
Your state, is it on in black and white?
I am just conveying what happened, what transpired before the
That is not the
division bench.
manner of conveying. Unless it is in black and white, I will not take notice of anything.
My friend
Many
was also
things,
there.
many things happen.
Because my friend was also there. It has got the honorable division bench has
Mister,
granted.
please understand the procedure of court. There are so many things which are observed in the court, which is expected from you, which is expected from the counsel. But unless it translates itself in black and white, it has got no relevance, at least for the other court. So it has been dismissed, you comply.
No, sir, it has not been dismissed. That is what I was
What
telling
happened?
you. It has been listed on 19th of August.
Adjourned.
Yes, it has been listed on 19th of August.
Okay.
Asking us, by that time you should be clear with our instructions. That is what has happened.
So we will just adjourn it.
That,
What is that LPA
I was
number?
saying that LPA 353 of 24. It is my duty to
That's law also
inform
explains.
Millets what has transpired, because that is why.
See, you could have simply said that the LPA is pending. We are not in a hurry to get the order complied. We know the procedure, that procedure has to be taken care of. Content Civil 737 of 2025. The learned counsel for the parties are present. They have jointly submitted that the matter be adjourned as LPA number 353 of 2024 has now been adjourned to 19th of August. And the Honorable Division Bench is actively considering the input. Is under is to be listed on that day. That should be sufficient. Pose this case on 29th.
Yes, because by that time, whatever has
On 29th of August.
obliged. Deeply obliged.
कोई और केस नहीं हुआ होगा, कोई याद नहीं.
स्टेटस
कोई बात.
Item 434, contains 745 of 2025.
Yes, please.
partly complied sir.
Complied?
Partly.
Partly means
Para 12 days sir. Page 22.
show cause.
No, it's my content.
Page 22. What do you want? What was the direction?
My demonstration upon filing of such representation, the respondent number 4 shall pass a result order after granting the facility of hearing to the petitioner within a period of 6 weeks from the date of defect. The result order will be communicated to the petitioner through speed post at the address of to be mentioned in the representation.
Which part of the order has been complied and which part has not been?
Representation का result order pass हो गया है, but regarding consequential benefits and monetary benefits related to
Reasoned order is in your favor.
yes, right, sir.
We fixed the in paragraph 7 of the show cause that we filed. Provisional pay fixation has been done. Further, it has been communicated that the provisional pay fixation has been approved with respect to the 5th revised pay scale and 6th revised pay scale.
So how much time do you need to give How much time do you need to give the monetary benefit of this?
That has to be disbursed by the university.
Have you given the money to university? You are representing whom? The state?
The state.
Right? So have you given that money to the university? Because money has to come from you, no? Who has to give the money?
I have to give.
Also, let me say one more thing.
Yes, mister?
So cause का पहला 7 लिखिए.
Para 7?
So cause का.
Show cause. I'm there. Tell me.
इसमें setting of initial appointment और date का कुछ बात नहीं किया है. They just fixed date fixation fix कर दिया है according to 5th and 6th television.
Okay. They have not shifted your date of
कुछ
initial
बोले नहीं. Reason order has not been communicated to me yet.
That is not in dispute.
Where is the
with
reason
respect-
order? Where is the reason order?
You file a supplementary. Because with respect to the date of shifting the
Para 10
date of
लिखिए.
appointment, that is not in dispute.
It is in dispute. Main case यही था लड़की.
Rest is all consequential. Where is the reason order? Yes, counsel. Who had to pass the reason order?
Respondent number 4, Director Higher Education.
With finance.
ऑर्डर पढ़ के समझ में नहीं आता है. Yes? Yes, counsel. आपको भी नहीं समझ आता है. उनको तो नहीं समझ आता. When there is a direction to pass a reasoned order, you should have annexed a copy of the reasoned order. बताइए.
I'll file a supplementary to that. It should have been there in the first place.
Contempt Civil 745 of 2025. Counsel for the parties are present. From the show cause, it appears that some decision has been taken, but the reasoned order has not been placed on record. The counsel for the petitioner has submitted that the bone of contention was initial date of appointment.
Shifting of initial date.
Shifting of initial date of appointment. Counsel for the opposite party state prays for some time to place the reasoned order on record. Further, it is not clear from the show cause as to whether the admissible amount has been remitted to the university for payment to the petitioner. Okay? Let the supplementary show cause be filed by 12th of August, post on 14th of August in the supplementary process. आज़ादी के पहले आज़ादी चाहिए.
Let it come out in the third week of August.
आज़ादी खत्म हो जाए. We want everybody to be free, and you also become free from the court.
Item 435, Contempt Civil 749 of 2025.
Yes.
Wait, please, Lords. After the last order, they have filed so cause. Whereby order of caste scrutiny committee has been annexed and the caste certificate has been rejected.
Rejected. Your caste certificate has been.
No, not mine.
Then?
I have filed Q warrant, writ of Q warrant. So the person against whom I allege that her caste certificate is fake, the caste scrutiny committee has found that yes.
That your allegation was
yes,
correct.
Yes, found.
चलिए हो क्या काम था आपका?
So they have served to me on 24th of July.
चलिए. Contempt Civil 749 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of opposite party. However, he has submitted that a show cause has been filed, annexing therewith an order passed by caste scrutiny committee cancelling the caste status certificate issued in favor of
Miss Alisa Kumar.
MS Alisha Kumari, who was respondent number 11 in WPS number 1112 of 2023. The learned counsel submits that so far as the petitioner is concerned, his grievance stands redressed, and he does not want to proceed any further in this contempt. Considering the submissions, the contempt procedures are dropped.
Item 436, contempt to 784 of 2025.
For 1 week time to file reply to the so cause. In the so cause, they have stated that the matter has been referred by the DLO in the September 2014. Land acquisition. This is a matter of land acquisition. Matter has been referred by the DLO before the Judicial Commission. But to our information, leadership, till date, almost 1 year has been passed. No reference case has been instituted.
कहाँ है लेटर बताइए?
Annexure B, that is Annexure B, your lordship, of the so cause, page 17.
There was direction to pass a recent order on this, and that's at page number 12 of so cause. The same has been passed, and the matter is of this is regarding the dispute of title. So it has been referred to
As per the
Thank you. Contempt civil 784 of 2025. Learned counsel for the parties are present. The learned counsel for the learned counsel for the petitioner has submitted that as per the show cause, the district land acquisition officer Ranchi has forwarded the matter to the Judicial Commissioner Ranchi for instituting a case.
That is land reference case.
Sorry?
Land acquisition reference case. That
For
will be-
land acquisition reference case. However, he submits that till date no such case has been instituted, and the petitioner is deprived of compensation under land acquisition process. Office is directed to call for a report from the Office of Judicial Commissioner Ranchi as to whether any land acquisition case has been registered pursuant to the aforesaid letter. Let this letter be accompanied. Let the letter contained in Annexure B to the show cause dated 21/7/2025. Sorry?
23/9/24.
No. Letter annexed as Annexure B to the show cause dated 21/7/2025. We also forwarded to the aforesaid authority. Let this order as well as the Annexure B to the show cause be communicated to the court concerned through fax. Post this case on 14th of August 25 in the supplementary cause list, awaiting the response from the concerned court. हो जाएगा ना आपका काम?
हाँ, बस वही हमारा सर्टिफाइड को भी मालूम नहीं मिल रहा इन्फॉर्मेशन से।
अभी आ जाएगा। नहीं हुआ होगा तो इंस्टीट्यूट हो गया।
वही हमारा ग्रीवेंस है बस।
Item 437, contempt suit 801 of 2025.
Order has been complied with.
May kindly see the order. Last portion, only last portion. There is no order. But this is there is no
Recent order was to be passed your edition.
The last paragraph में kindly permit.
हाँ, but
अंचल अधिकारी के प्रतिवेदन के अनुसार खाता संख्या 17 प्लॉट संख्या 786 स्पष्ट रूप से सरकारी अथवा गैर मजरूआ भूमि नहीं है। अभियंत्रण शाखा रांची नगर निगम द्वारा अभिवेदित कि रोड रांची नगर निगम द्वारा निर्मित है तथा निर्मित जमीन रहती है। यह सड़क संख्या 17 प्लॉट नंबर 786 मौजा आत्मा रकबा 5 एकड़ 64 डिसमिल पर निर्मित है। श्री रविंदर गोप इज द पिटिशनर द्वारा पूर्व में दिए गए रसीद के अनुसार खाता नंबर 17 प्लॉट नंबर 786 मौजा हातमा और रकबा 9 डिसमिल जमीन पर समर्पित किया गया। उनके नाम से लगान रसीद निर्गत है। भूमि की प्रकृति रैयती होने के कारण भूमि के अधिग्रहण करने की अनुशंसा का आदेश दिया जाता है। भूमि अधिग्रहण भूमि अर्जन अधिकारी रांची से प्रश्नगत सड़क की भूमि का सही और वैध रैयत चिन्हित कर नियमानुसार उनके अधिग्रहण की प्रक्रिया शुरू करने का अनुरोध किया जाए। उक्त हेतु अभियंत्रण शाखा अपनी अधियाचना जिला भू अर्जन पदाधिकारी को भेजना सुनिश्चित। मेरा एप्लीकेशन डिसाइड
आगे क्या है? श्री रविंद्र को ये कौन है?
यही पिटिशनर श्री रविंद्र प्रश्नगत सड़क जो कि खाता नंबर 17 प्लॉट नंबर 786 मौजा हाथमा पर निर्मित है का स्वामित्व साबित करने में असमर्थ रहे। यहाँ तुम कह भी रहे कि रसीद मेरे नाम से, तो फिर असमर्थ कैसे?
Total area is of your ladyship. Kindly come to page 11, your ladyship. Several opportunity was given to the
अपॉर्चुनिटी छोड़ी रही, सेल्फ कॉन्ट्रडिक्शन नहीं है।
your ladyship total area वहाँ पे 87 डिसमिल है, उसमें से 9 डिसमिल petitioner का है। तो एग्जैक्ट वो एरिया किनका आता है वो चीज ये prove
ये
नहीं
तो
कर
पूरा खाता नंबर 17 लिख दिया।
नहीं, पूरा खाता नंबर नहीं है,
ये
वो
तो
किसी
लिखे
और
लास्ट में श्री रविंद्र को प्रश्नगत सड़क जो कि खाता नंबर 17 प्लॉट नंबर 786 का टोटल एरिया कितना है?
5 एकड़ ही लिख भी रहे ऊपर में 5 एकड़ 64 डिसमिल
नहीं
ये ऊपर ही लिख रहे हैं।
लॉर्डशिप पैरा पेज 12 your ladyship।
हाँ बताइए।
श्री रविंद्र गुप्त द्वारा भूमि स्वामित्व संबंधी कोई कागजात समर्पित नहीं करने के उपरांत रांची नगर निगम द्वारा पत्रांक सचन सच
श्री रविंद्र गोप के नाम मात्र 9 डिसमिल जमीन का ही रसीद कर।
यस
ठीक है, तो 786 में उनका 9 डिसमिल है ना?
बस वही हम
टोटल वहाँ पे 87 डिसमिल है already।
He is not asking for the heaven.
No, you already, but
He is only asking for 9 dismil.
The road is constructed in only 5.63 dismil. That the petitioner has not been able to prove use.
Yes. At least 9 dismil का तो he is having receipt.
Yes,
right?
That is.
So when you say at the end that he has failed to prove his title with respect to खाता number 17 and plot number 786, कम से कम इतना तो बोलते हैं, at least to the extent of 9 dismil he has been able to prove.
वो तो है ही, वो तो हमारे ऑर्डर में है कि उनका 9 डिसमिल का है।
उसको थोड़ा क्लैरिफाई कर दीजिए, ठीक है? ऐसा कंफ्यूजन, ऐसा कॉन्फ्लिक्टिंग ऑर्डर जैसा लग रहा है, इसको थोड़ा सा क्लैरिफाई कर दीजिए that he has been able to prove only with respect to 9 dismil and whatever be the land required for
कोई वहाँ क्लेम भी नहीं करने जा रहा है उस जमीन पर, उस
क्लेम भी नहीं कर रहा और इनको काफी अपॉर्चुनिटी दिया गया वहाँ हियरिंग because order was passed.
He is not claiming the entire.
No, he is claiming compensation on the road built on that.
That's right. Now there is a proposal for acquisition.
Yes, that is.
है ना? जब तक acquisition का proceeding नहीं हो जाएगा ना, ये केस यही pending रहेगा। हम इसको छोड़ेंगे नहीं यहाँ पर। रास्ता आप ले लिए हैं, है ना? We will see.
मेरे अलावा कोई कंप्लेन भी नहीं कर रहा, क्लेम भी नहीं करने जा रहा कि हाँ इसमें हमको कंपनसेशन, और लोगों को बुलाए उन लोग रिफ्यूज कर गया।
The right owner has to be given the compensation.
That certainly rightful owner. हो सकता है somebody else might come
that is
at the time of acquisition, quite possible.
That is acquisition का समय का, that is a procedure.
That is a procedure. अगर मान लीजिए इनका नाम आ जाता है, we will just keep it pending for some time. कम से कम acquisition का आप procedure तो initiate करिए।
तो पहले requisition तो आएगा।
हाँ, ठीक है।
अब वो जा चुका
है। लेकिन इसको clarify करिए।
That it itself is not clear.
You just pass a small order clarifying this position.
And they should
कि
give
उनका
a copy
9
of the
dismil का तो
affidavit.
claim उन्होंने किया है ना? For the rest of the part, he has not been able to lodge any claim.
They should serve a copy
You
of the
can also
affidavit to the
say,
state also.
you can also say that this would be subject to any claim made during acquisition process. That can also, because the receipt will not decide the title. वो भी आप
नहीं, हम तो ऐसे लिखे भी हैं कि कौन डॉक्यूमेंट
decide the possession and actually it should be demarcated and thereafter the requisition should be.
That has to be done by the भूमि अर्जन पदाधिकारी.
आप समझ गए ना क्या करना है? आप करके
They should serve a copy of the affidavit because हम ही को बोल रहे हैं और अपनी
पिटिशनर उस ऑफिस पिटिशनर भूअर्जन ऑफिस में जाके परेशान है, वहाँ गया ही नहीं है।
कौन बोल रहा है जाने के लिए आपको?
नहीं, उस भूअर्जन ऑफिस में
यहाँ आने के बाद कहीं जाने का जरूरत नहीं है। This I do not permit. ना कोई बुलाए तो बोलना है कि कोर्ट में आ जाए।
हाँ ठीक है।
यहाँ आने के बाद कहीं जाने की जरूरत नहीं। जब तक यहाँ नहीं आ रहे हैं सब जगह होकर ही आते हैं लोग। Contempt Civil 801 of 2025. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that a reason order has been annexed, which has been passed by the additional
Municipal by the chief engineer officer.
नहीं।
नहीं correspondent को ही
अपर नगर आयुक्त क्या हुए?
Municipal
Commissioner.
Commissioner.
By the municipal commissioner.
Assistant upper.
By the assistant municipal commissioner. However, the operative portion of the order is self-contradictory, which is creating some confusion. The learned counsel has submitted that in the second last paragraph, it has been recorded that the petitioner has shown rent receipt to the extent of 9 decimal of land, and at the end it has been mentioned that the petitioner has not been able to show his title. The learned counsel has submitted that. No, the learned counsel for the opposite party has submitted that appropriate order will be passed clarifying this position. However, there can be no doubt that mere issuance of rent receipt will not create any title in favor of one or the other person. And once the acquisition process commences, compensation will depend upon the claimant at the stage of acquisition. The learned counsel for you are representing whom?
RMC.
The learned counsel for the state has submitted that unless the property is demarcated, there cannot be any acquisition. So,
proper requisition.
therefore, proper requisition is required to be sent by the municipal commissioner. At this, the council for the municipality has submitted that he will take up the matter with the municipality and appropriate steps will be taken. चलिए आप इसको 29th August post on 29th August सर्कल ऑफिसर को बुलाकर डिमार्केट करके उसको बाउंड्री निकाल के कितना जमीन चाहिए देन यू सेंड द रिक्वेजिशन है ना सर्कल ऑफिसर आएगा ना उसका रिपोर्ट बना के बाकायदा
उसके बाद गवर्नमेंट अमीन्स होता ही
जो भी सर्कल ऑफिसर गवर्नमेंट अमीन जो भी करेगा
Item 438 Contempt Civil 945 of 2025.
Yes, petitioner.
In this case, the petitioners are working on radium lots since last 18 to 26. They were directed to file petition for the Deputy Commissioner of Devon lot for consideration of their cases for ration lot. The petitioners filed the petition on 30th of April 2024.
No show cause filed.
No.
आपका रिप्रेजेंटेशन कहाँ?
Representation annexure 2 at page 21. It has been received on 30th of April 2024.
नहीं आपको तो रिप्रेजेंटेशन में देना था सपोर्टिंग डॉक्यूमेंट and it should also include the details of the payment made to the petitioner from time to time.
We have annexed the writ petition was also annexed body. In the writ petition, all the annexures were there. अनुलग्नक में दायर writ अनुलग्नक सहित चाहे
Contempt Civil 945 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of the state. He submits that order passed by this court dated 4/4/2024 has not been complied in spite of filing of representation dated 30/4/2024. He has also submitted that the opposite party number 4 has no regards for the orders passed by this court.
Party number 2.
Opposite party number 2 has no regards to the orders passed by this court. Let notice be issued to the opposite party number 2 through the concerned police station as to why a contempt proceedings be not initiated for willful and deliberate non-compliance of order dated 4/4/2024 through the concerned police station. The counsel for the state is directed to through the concerned police station pose this case on the requisite are filed. The requisites be filed within a period of 1 week. Pose this case on 12th of September 2025, awaiting service report. Since the counsel for the state is not present, let a copy of this order be forwarded to the office of the Advocate General.
Item 439, CRMP 1821 of 2025.
Yes, please.
For restoration of criminal division, it was dismissed for default. And now the same was.
Criminal division was filed against which order?
Criminal division was filed against the order of granting maintenance.
Granting maintenance. Okay, when was the criminal division filed?
In this case, maintenance order dated 5/4/19, maintenance alteration case number was modified and maintenance amount was increased. Now the petitioner is my his retired person is already retired. However, I am needed for this condition.
CRMP number 1821 of 2025. Counsel for the petitioner is present. This petition has been filed for restoration of criminal division number 314 of 2024. It stood dismissed due to non-removal of defects in terms of order dated 21/6/2024. He submits that the matter arises out of order relating to enhancement of maintenance filed under section 127 of CRPC. By the order impugned in the criminal division, the petitioner was supposed to pay ₹7,000 per month to the opposite party, his wife, and ₹4,000 per month to each minor daughter until they get married or gainfully employed by 10th day of each succeeding month. The learned counsel submits that किसने नहीं remove किए defect?
And that entire defect till date now, because one order of earlier proceeding 2011-2003 was required, but order dated 22/11 23 was required. The petitioner however now got the certified copy of that document and has filed.
The learned counsel has
On 23/2025.
submitted that the petitioner had applied for certified copy, but he could not receive the same within the time granted for removal of the defect. What about other defects?
All the defect has been removed. Only that the certified copy of that document was not obtained.
The learned counsel has submitted that. He has now received the certified copy and he shall file it. There are other defects also. There were other defects also which he submits that he has already removed. Considering the aforesaid submissions, the time granted for ये annexure 3 में क्या लगा है?
Annexure 3. That was my petition was the petitioner was given liberty in that case, the restored with condition that he shall remove all the defects till 10/1/25, and in case he is not obtaining the certified copy, he shall file a petition for extension of time. And I had filed a petition for extension of time within time, but the case could not be registered, and the order has now also been obtained, and he is filing the aforesaid order.
तो एक CRMP के बाद दूसरा CRMP फाइल कर दीजिएगा.
Because I was
Because means once there is a CRMP for restoration and it has been dismissed,
that extension
you will file another CRMP.
But extension is pending.
I do not know.
Extension, I have given the number of the INR.
उससे क्या मतलब है हमको?
INR
आपको ये CRMP का restoration plan मांगना था. ये तो restoration square हो गया. आपको लगता है बेवकूफ है हम लोग?
No, but in that order.
आप बताइए, if there is a petition for restoration and that restoration petition में I have given an extended time to remove the defect, which is again a preemptory order, right? And ultimately that order has taken effect and your restoration application has been dismissed. Then you will file another restoration application, or you have to get the restoration petition restored.
Because I was given a liberty to file extension application.
I do not know. तो पहले तो CRMP 2653 का ना restoration होगा. तीस साल हो गए ना प्रैक्टिस करते हैं. नहीं समझ आया अभी तक. दिमाग मेरा कमजोर हो सकता है, नजर कमजोर नहीं. ठीक है ना? इसको डिसमिस कर देते हैं. कुछ नहीं हो सकता.
Liberty.
What liberty? I'll dismiss it as it is. कोई लिबर्टी का काम नहीं है.
Liberty will be given.
कोई लिबर्टी का काम नहीं है इसमें.
For restoration.
वाइफ और बेटी को पैसा देना है ना, देते रहिए. 4,000 5,000 रुपए के लिए लड़ते रहते.
Retired person है वो.
क्या चीज?
बेड पर है. Already retired from service.
रिटायर्ड पर्सन है, बेड पर है, अच्छा है, पोस्ट डेट बेनिफिट मिल जाएगा उसको. क्या बोलेंगे आपको? 5,000 रुपए. You are a retired person, must be getting pension.
Then on merit to decide. Merit to
कोई
decide.
बात नहीं, अभी मेरिट पे आपका रेस्टोरेशन डिसाइड कर. फिर से लिखिए. CRNP number 1821/2025. This petition has been filed for restoration of criminal revision number 314 of 2023, which was dismissed due to non-compliance of order dated 21/6/2024. The learned counsel for the petitioner has submitted that since the petitioner could not get the certified copy, therefore the preemptory order
I may be permitted to withdraw.
passed in this.
I may be permitted to withdraw.
हम तो कुछ cost लगाने का सोच रहे हैं.
I may be permitted to withdraw.
After counsel for the petitioner seeks permission to withdraw this petition, accordingly this petition is dismissed as withdrawn.
Sign कर लीजिए.
खत्म हो गया लिस्ट. कॉल करिए, देखते हैं हियरिंग में कौन कौन तैयार है. इस कोर्ट में कभी कभी ही लिस्ट खत्म होता है, वेरी रेयरली. चलिए कॉल करिए.
Item 4 and 14. WPS 5535 of 2015.
यस पिटिशनर, आपकी तबीयत ठीक हो गई दिवाकर जी? पिछली बार आपके एक्सीडेंट के ग्राउंड पर एडजर्न. ठीक है. Yes, sir.
Petitioner has assailed the order of dismissal from service. He was a constable appointed on 21/6/1992 and removed on 17/7/2014 after rendering around 22 years of service. 3 charge sheets have been served to the petitioner.
3 charge sheets.
Yes. Annexure 1, Annexure 2 and Annexure 5. Threefold charges are there basically. First is that the petitioner is a habitual absconder from service. He did not underwent training. Remained unauthorized absence for 7 times in his entire service career.
7 times.
Yes.
Absconder.
Yes. Second charge sheet, as per the medical board which was formed in pursuant to
This
the
is first charge.
This is first charge sheet.
Second
charge sheet and Annexure 2. When he was sent for training in JAT training center on 21/10/2012, he went by availing 3 days permissible leave and supposed to join on 25/10/12. He remained absent for 197 days.
Okay.
The second charge that there is, he was supposed to be 50 years of age at the time of examination by the medical board, but in there are 2 reports of the medical board. In the first report, his age has been found to be 58 years. In the second, 50 years. Now these 2 contradictory date of births are there. So this is also one of the charge. How he can become 58 years means he has taken the service by falsifying the statement that his date of birth is actual 1963. So there is discharge also. And the third is reiteration.
Regarding date of birth dispute.
Date of birth dispute.
Then?
And third is reiteration of all this. Annexure 5.
So what is your point? क्या होगा इसमें?
कुछ है नहीं.
होगा कुछ. ना रिकॉर्ड बहुत खराब है. पता है?
2 ग्राउंड हम बता देते हैं मेलोड लिखवाने के लिए बस. 2 ग्राउंड ये है कि जो 7 बार ये लोग पनिशमेंट का बोल रहे हैं तो वो 7 बार पनिशमेंट के लिए हम 7 बार पनिशमेंट पा चुके हैं तो उसको कंसीडर करना दोबारा इट अमाउंट्स टू डबल जेल पार्टी इन काउंटिंग दोस थिंग्स. एंड सेकंड वो 843 झारखंड पुलिस मैनुअल.
My submission is that I was suffering from mental illness. Medical board also held कि I am unfit for physical training. Annexure 3 में medical board का report है. इसमें Annexure 3 my lord the uses for
Page number?
Page 33. This medical board was constituted by the respondents, and 3 or 4 doctors were the government doctors. Last opinion part, page 33, Annexure 3. Last part में देखा जाए opinion. In our opinion, Sri Dinesh Prasad Srivastava is unfit for basic training, including running of 10 km morning and evening. So this is the contention because this medical report was made after taking into consideration my mental illness and physical illness. And in this particular document, my age has been depicted as correctly as 16/1/1963. In this itself, second line, date of
वो तो
birth.
आपके आई कार्ड के बेसिस पर है ना?
हाँ भाई, तो इसमें कोई contradiction नहीं आया इसमें. बस इतना ही है मेरा ground of question.
आपको क्या बोलना?
Your Lordship, with regard to the submission made by the petitioner that the medical opinion they have taken into consideration the mental illness of the petitioner. Nowhere from the record from perusal of annexure 3, if Your Lordship would see, the doctors have nowhere stated that they have taken into consideration the medical illness of the petitioner. Therefore, he is not able to run 10 kilometers morning and evening. They have simply stated, in our opinion, Sri Dinesh Prasad Srivastava.
He has not kept good health, which is also a part of his
physical
job.
health. Your Lordship.
Yes, good health.
No, it is not with regard to mental health. There is no consideration.
And there is no disease as such mentioned.
Yes, Your Lordship. It is only stated that in our opinion he is unfit for basic training.
This happened on 23/7/2013.
23/7.
When was he to be trained?
2012.
2012. This is subsequent to that.
Yes, Your Lordship.
So it has got, otherwise also has got no value.
And other submission that all the due procedure established by law has been followed by the respondents. Your Lordship, the order of dismissal has been passed, which is proportionate because he was unauthorizedly absent, being in a task force in a police. He should be.
Likhil, WPS number 5535 of 2015. Heard the learned counsel appealing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had joined his service in police force on 21/6/1992, and after completing 42 years, 22 years of service, he has been dismissed on 17/7/2014. The learned counsel submits that 3 separate charge sheets were issued to the petitioner as contained in Annexure 1, 2 and 5. So far as Annexure 1 is concerned, it is relating to habitual absconding from service and that he did not take the training, and 7 times he has remained absconder. The learned counsel submits that once he has already been punished for being absconded in past, the same cannot be taken into consideration, and that would amount to double jeopardy. So far as Annexure 2 is concerned, he submits that the allegation is that on 21/3/2012 he was to take training, but he went for 3 days leave and was supposed to join on 25/10/2012, but he remained absent for 197 days without leave and without intimation. The learned counsel has referred to Annexure 3 to submit that on 23/7/2013 he was examined by the medical board, and his mental and physical condition was also examined, and it was opined that petitioner is unfit for basic training within bracket, including running of 10 kilometers morning and evening. The learned counsel submits that since the petitioner was unfit, therefore he did not participate in the training. He has also submitted that the petitioner was mentally unfit. The learned, with respect to Annexure 5, the learned counsel has submitted that there is another dispute regarding his date of birth, and it has been alleged that he has suppressed his date of birth, and at two different medical reports there are two different date of birth, and the difference is by 7 years.
One more. He has not been paid the subsistence allowance from September 13 till date of his dismissal. That has been admitted by the respondents in counter affidavit also.
The learned counsel has also submitted that the petitioner was not paid the subsistence allowance from September 2013 till the date of dismissal. The learned counsel for the respondents has opposed the prayer and has submitted that there are serious charges which was proved against the petitioner in the departmental proceedings, and all the basic procedure including natural justice has been duly followed in the present case. He has referred to Annexure 3 and has submitted that the Annexure 3 does not reveal that the petitioner was otherwise suffering from any disease. He has also submitted that Annexure 3 is dated 23/7/2013, although his training was in the year 2012 itself. The learned counsel submits that the writ courts do not sit in appeal against the orders passed in the departmental proceedings, and the order of dismissal imposed is adequate and proportionate to the charges level and proved against the petitioner. इस subsistence allowance का क्या करना है?
Lordship, in our supplementary counter affidavit, we have stated that since he was not present on duty even after the authorized
We
leave.
will simply say that so far as this claim of subsistence allowance is concerned, you consider as per law.
Yes, sir.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and after going through the records, this court finds that there has been serious charges against the petitioner and no violation of principles of natural justice has been pointed out by the learned counsel for the petitioner during the course of hearing. And the charge sheets were issued taking into consideration his past conduct as well. And the petitioner had also repeatedly absented himself from duty without taking leave. So far as the sole annexure which has been pointed out by the counsel for the petitioner, that is Annexure 3, the same is dated 23/7/2013, and the petitioner was to undergo training in the year 2012 itself. Therefore, the said document does not help the petitioner in any manner. Moreover, the said document is not reflecting any disease of the petitioner, physical or mental. He has been simply found unfit for training. The said document does not help the petitioner in any manner. Considering the totality of facts and circumstances, being conscious of the fact that writ courts do not sit in appeal against the orders passed in the departmental proceeding, which can be interfered in cases of violation of principles of natural justice causing prejudice, or in case of violation of any statutory provision, or when the punishment is disproportionate to the charges leveled and proved. None of such grounds have been made out in the present case in the light of the arguments which has been advanced by the petitioner. Accordingly, this court finds no merit in this writ petition, which is hereby dismissed. However, so far as the grievance of the petitioner regarding payment of subsistence allowance is concerned, he can raise such grievance before appropriate authority, who shall consider the same as per law. And if any amount is found admissible, the same shall be remitted. पनिशमेंट में नहीं किया हुआ है ना, फर्दर कोई और सब्सिस्टेंस अलाउंस नहीं मिलेगा, नहीं दिया है,
वो तो कर भी नहीं सकता पनिशमेंट।
आई डू नॉट नो, कभी कुछ कर ही दे,
नहीं वो हो ही नहीं सकता, पुलिस मैनुअल के हिसाब से पनिशमेंट ही नहीं, सब्सिस्टेंस अलाउंस कैन नॉट बी विथहेल्ड।
जी चलिए अगला क्वेश्चन ये कौन सा है? 441
Item 441, WPS 6020/2016.
Yes, petitioner.
Last time they have taken that submitted and then
Petitioner has expired. Right? देखिए WPS number 6020/2016. Nobody appears on behalf of the petitioner. On the last date, that is on 18/7/2025, it was submitted that the petitioner has expired, and at the prayer of the counsel for the petitioner, the matter was adjourned for 2 weeks. No petition for substitution has been filed in the present case. Counsel for the respondent has submitted that all admissible amount has been paid to the petitioner, right, during his lifetime.
This is BCCL has also submitted.
You have paid during his lifetime. Should I record or should I not record?
Yes, Lord. On behalf of BCCL also.
हाँ, और BCCL की तरफ से लिख देंगे. Considering the fact that the petition has already expired, there is no point keeping the matter pending. Accordingly, this petition is disposed of.
Well, like my appearance from CMP for that.
आप अपना appearance में पास होगा नहीं?
Also, case item 418, contempt suit 784/2024.
Sir, are you there in this case? यही वाला है ना? चलिए. ये यूनिवर्सिटी का कहाँ से? इसमें यूनिवर्सिटी का तो कोई रोल नहीं.
784/24
हाँ ठीक है. अब बताइए क्या बोलना है? You want to say anything? Kindly explain.
इसमें हमारा लास्ट शोकॉज देख लिया जाए. Filed on 18/3/2025.
18/3, okay. Yes.
Para 4 onwards, I have stated the entire facts of the case. That the matter is for granting the status of permanent government employee to the petitioners or taking such major decision. The Principal Secretary Department of Rural Development is not competent authority, and state cabinet can only take major decision as per rules of executive business of the state government. By oath number so and so, it has been submitted that after getting the opinion suggestion of Law Department and approval opinion suggestion of Finance Department, Government of Jharkhand, proposal was sent to the Cabinet Secretariat and Coordination Department, Government of Jharkhand, to place it before the State Cabinet. By oath number so and so, it is submitted that the Cabinet Secretariat and the Coordination Department, Government of Jharkhand, directed to make their approval, to take the approval of the
approval on the proposal from the Department of Personal and Administrative Reforms, Government of Jharkhand, and return the concerned file to this department. Accordingly, the concerned file has been sent to the so and so department for their approval. Further, it is submitted that Department of Personal and Administrative Reforms, Rajbhasa, Government of Jharkhand, has given his consultation to take this matter before the higher authority, Chief Secretary with the Finance Department. If decision is taken in favor of the petitioner, it will involve huge financial burden on the government. So, financial aspect, including determination of date for pension, are being considered at a higher level. On the aforementioned facts, it is requested to grant 4 weeks time. Now,
ये 4 weeks time तो हो गया?
thereafter, ये तो था पहला एफिडेविट कंसल्ट. उसके बाद हमने फाइल किया. ये that was filed on 17/4.
17/4.
इसमें पैरा 8.
पैरा 8 पढ़ी. Yes, please. Yes, please explain. Is there anything additional you have mentioned here?
Even though it is not
Para number?
Para number 8. That it is submitted that after getting the approval of the Law Department and Finance Department, the proposal was sent to the Cabinet Secretariat and Coordination Department, Jharkhand. After getting certain observations, the proposal was returned back. See me.
Yes.
24/7
24/7 देखिए तो चेक करिए 24/7 को कोई एफिडेविट फाइल हुआ है क्या?
इस सेकंड मैटर में फाइल हुआ है ये कंटेंट 848 ऑफ टेक्स्ट कैश मैटर इसलिए
कब फाइल की है?
24/7 का 24/7
31/7 को भी फाइल की है. Exemption from joining.
नहीं वो उससे पहले.
बताइए.
Hmm.
24/7. Yes.
Para 6. Subject matter relates to grant of regularization and the status of permanent government employee to the petitioners, which, as per the prevailing rules of executive business of the state government, requires approval of the state cabinet and does not fall within the jurisdiction of the Secretary, Rural Development Department. It is respectfully submitted that the process of obtaining such approval is underway, and all the necessary formalities regarding the processing and approval of the file has been completed, and the file concerning 127 employees, including the present petitioners, was forwarded to the cabinet and waiting for cabinet decision. So here only 15 petitioners are there in the present contempt application. The proposal of 127 persons is pending before the cabinet, and it is beyond the capacity and beyond the reach of the departmental secretary to get the approval. It is the chief secretary or the cabinet secretary who places the file and gets the approval from the cabinet. Once now, so far as the Rupa Kumari case is concerned, now I have examined that case. here in this case also, although payment has been made, there is no dispute. I have inquired, but
Is the case of Rupa Kumari also sent for cabinet approval?
Yes, it is pending.
It is
Same
pending.
file, same file.
In the same file,
In the
her name
same
is
file.
also there,
No, cabinet note with respect to all the petitioners,
including Rupa Kumari.
Including Rupa Kumari. Now we have passed the order as the undertaking was given before the Honorable Supreme Court. Now it is a conditional order. What 3 conditions are there? If the cabinet doesn't approve, then the amount will be recovered. If it is approved, then the amount will be adjusted under the appropriate head. And third condition is, the third was departmental minister, approval from the departmental minister was taken for the purpose of payment because of the order of the Supreme Court, and this is subject to approval of the cabinet. Now this is the present position which I have placed before your Lordship. Now these files are pending before the cabinet. This is not only the petitions, but 127 petitions who are even not before your Lordship, but they were common cause. Therefore, it was taken decision to place. Now it is beyond the reach, and
Where is the order passed in the case of Rupa Kumari?
that
Where is
order
the
I don't
compliance
have.
order?
Let them file an affidavit
No, no.
enclosing all the documents
No, last
relating to
time,
Rupa Kumari, so
last
that
time, no.
नहीं, हमको आज तक कोई एफिडेविट नहीं मिला, कोई डॉक्यूमेंट मिला, अभी ये डॉक्यूमेंट मिला है हमसे, इससे ज्यादा कुछ नहीं
अभी
मिला।
नहीं मिला है, ये पिछली बार भी था। प्लीज पिछली बार का रिकॉर्डिंग निकालिए और चेक करिए।
ये कोर्ट में ही दिखाए थे, रिकॉर्डिंग में भी मिल जाएगा, लेकिन कोर्ट के बाहर हमको कहीं नहीं मिला।
22/4/25 का ऑर्डर
आप
देखा
तो कुछ भी बोल देते हैं, ओरली बोल देते हैं, भाई
Really क्या बोलते हैं? It is on record. Don't suggest so.
आपके ऑर्डर
Don't be so.
जो ये ऑर्डर है मिस्टर के श्रीनिवासन थे, इन्होंने बताया था कि उन्होंने ही ये ऑर्डर पास किया है, so he cannot say that he is unaware of this.
I am not saying that
And
he
therefore,
I am not saying so.
he had joined the
aware, he
proceedings.
had, yes.
He is aware. Now you said that it is on a different footing altogether.
Different footing means
No payment has
different
been.
footing यही था कि it was made as, इसमें हमने ऑर्डर में भी लिखा हुआ है, देखा जाए हम सिर्फ ये ऑर्डर का हम 2 लाइन पढ़ देते हैं। इसमें लिखा हुआ है अनुपालन हेतु न्यायालय द्वारा अनुपालन हेतु विशेष परिस्थिति में निम्नवत निर्णय लिया गया, और निम्नवत निर्णय में ये 3 शर्त रखी गई। और शर्त क्या है? शर्त यही है कि भविष्य में सक्षम
नहीं पहले वादी श्रीमती रूपा कुमारी सिन्हा करिए।
अच्छा वहाँ से पढ़े,
वहाँ से पढ़िए।
हाँ वादी ये निर्णय लिया गया,
पढ़िए ना।
वादी श्रीमती रूपा कुमारी सिन्हा सो एंड सो सेवक मानते हुए वेतन पुनरीक्षण सहित एसीपी एमएसीपी का लाभ देते हुए बकाया अंतर राशि का भुगतान किया जाएगा।
सरकारी सेवक मानते हुए।
हाँ वो तो डिसीजन लिया ही हुआ है।
आगे पढ़िए।
डिसीजन हमने इनका भी लिया हुआ है।
आगे पढ़िए।
सेवानिवृत्ति उपरांत सरकारी सेवक को अनुमान्य सेवांत लाभ यथा अवैध उपार्जित अवकाश के बदले नगद भुगतान, औपबंधिक उपदान तथा औपबंधिक पेंशन की गणना कर वादी के खाते में प्रोविजनल पेंशन जो है ये दिया जाएगा। ना ये पेंशन देने के लिए, ये तो डिसीजन हुआ, देने के लिए 3 शर्त रखी गई है। उक्त शर्तों के अंतर्गत त्वरित रूप से प्रदत्त है। क में है जिला अंतर्गत संधारित किसी मद में उपलब्ध राशि के तत्काल वादी को भुगतान किया जा सकता है। भविष्य में सक्षम स्तर से महिला प्रसार पदाधिकारी के सेवा के संबंध में लिए गए निर्णय से यह आच्छादित होगा। थर्ड में है महिला प्रसार पदाधिकारी के पक्ष में निर्णय नहीं होने पर, जो पूछ रहे थे, पर भुगतान की गई राशि का एक मुश्त वसूल कर ली जाएगी। फोर्थ में है महिला प्रसार पदाधिकारी के पक्ष में निर्णय होने पर भुगतान की राशि का समायोजन शीर्ष में कर लिया जाएगा। 8 में है उक्त आदेश पर माननीय मंत्री ग्रामीण विकास विभाग झारखंड रांची का अनुमोदन प्राप्त है। तो ये these were the conditions which were complied for making payment and they have been paid also. Although contempt is pending, but we will be filing show cause that we have made the payment in compliance of this direction. Now this is the present position as of now. Now your lordship may pass an order. order कर दीजिए, we will pass an order.
There is no reason to give a differential treatment to others.
There was a reason differential treatment.
No, reason
there
क्या
was a
है?
reason.
Reason ये है कि आपने सुप्रीम कोर्ट में undertaking.
नहीं, वही that was the special
Why
reason.
did you give an undertaking?
नहीं, I gave an undertaking in the Supreme Court. That
That's
was
right.
the special circumstances.
What special? What was so special about?
Special about that we had given an undertaking.
No, what was so
now
special?
Here we
You see, didn't you realize while giving undertaking that if you give an undertaking for Shrupa Kumari, what will happen to similarly situated persons?
that I cannot comment on that. What happened
Yes,
in Supreme
yes.
Court that
No,
is.
I just want to know, when you give an undertaking before a court of law, right? Then such undertaking.
That was with respect to one case.
This is what I want to know. That are
That
you
was only
not
with respect to one
conscious
case,
of the
and
fact?
for that purpose only the
Are
special.
you not conscious of the fact that there are identity?
Not only these petitioners,
Yes.
there are 127 petitioners
सभी का यही करिए.
implies.
सभी का करिए.
तो ऐसा डायरेक्शन दे दीजिए तो
हम
कर
डायरेक्शन
लेंगे.
कर रहे हैं ना. अभी पहले कंटेम्प्ट प्रोसीडिंग इनिशिएट करेंगे. I'll pass an order to that effect. देखिए. Contempt Civil 848 of 2023. Learned counsel for the parties are present. बाकी सब में भी सप्लीमेंट्री शो कॉज फाइल किए हैं. एक में तो ये
एक में किए हैं because there was a common order.
नहीं तो इसी रिकॉर्ड में फाइल किए हैं कि और बाकी क्योंकि दूसरा आप दूसरा केस से रेफर किए हैं.
नहीं 848 से because I am appearing in that case only. In other cases Sachin Kumar and Rahul Sabur is appearing.
840 में
848.
848 में सारे एफिडेविट्स फाइल्ड हैं जो दूसरे केस में फाइल है.
More or less filing. नहीं सर.
This petition has been filed for this batch of petitions have been filed alleging willful disobedience and deliberate violation of the order dated 19/5/2023 passed in WPS number 6226 of 2011 and other analogous cases.
एक चीज इंडिकेट कर रहा है जो रीट कोर्ट का जो डायरेक्शन है ना उसको भी खाली देख लीजिए. देयर इज नो एज सच क्लियर मैंडेमस.
सब चीज देख कर ही ऑर्डर करेंगे. ऐसा ऑर्डर करेंगे कि आपको इस ऑर्डर को या तो कंप्लाई करना पड़ेगा या फिर आपको
कोई दिक्कत नहीं.
इसीलिए हम आपकी सारी पॉसिबिलिटीज को देखते हुए ठीक है. यू कैन ट्रीट पीपल लाइक दिस. सिलेक्टिव नहीं हो सकते.
अब हमारे लिए
absolutely you know it is shocking to this
हुजूर का कहना एकदम सही है.
You
लेकिन हमारे लिए being the principal secretary I have the certain restriction.
I appreciate that. I appreciate that. I will record it also. Okay. The learned counsel for the petitioner has submitted that a batch of writ petitions were disposed of by this court considering every aspect of the matter relating to the past history of appointment of lady extension officers at the stage prior to creation of state authority. The learned council submits that the order impugned in the petitions were set aside and the government was and the Principal Secretary, Rural Development Department, Ranchi, was required to scrutinize the background of the appointment of extension officers within bracket industry and commerce, bracket close statistical investigators on one hand and that of lady extension officer on the other, taking into consideration the conscious decision of the state government to take a different mode of selection of lady extension officer to ensure better participation of local women and whether in this background different mode of selection of lady extension officer could be a reason to treat lady extension officers differently from the extension officer within bracket industry and commerce and statistical investigator when mode and manner of creation of post of all the extension officers appear to be identical. He has also submitted that it was directed that the authorized one or two representatives of the petitioner shall approach the Principal Secretary, Rural Development Department on 3/7/2023 by filing a detailed common representation along with a copy of the order, and the Principal Secretary was supposed to look into the grievance of the petitioner, give a hearing and pass a reasoned order by 14/8/2023. And the reasoned order was to be communicated to the petitioners through email/post. The learned counsel submits that in spite of filing representation, the order passed by this court was not complied and the contempt cases were filed way back in the year 2023 itself. He has further submitted that in the meantime, following the same order passed in WPS number 6226 of 2011 and other analogous cases, a coordinate bench of this court had passed an order dated 12/12/2023 in WPS number 4792 of 2018. And the coordinate bench and a prayer was made in the said writ petition by the writ petitioner Rupa Kumari Sinha that since the resolution contained in memo number 1845 dated 16/5/2018 was already quashed by this court in WPS number 6042 of 2015 and other analogous cases, no useful purpose would be served in directing the petitioner to approach the Secretary Rural Development Department, as the same would be a tedious exercise on her part, and the court was, and a prayer was made to determine the admissible payment of post-retirement benefits such as gratuity, leave encashment, as well as benefit of ACP, MACP and pay division to the petitioner Rupa Kumari Devi. The Learned Counsel has submitted that in such circumstances, the Learned Counsel submits that the coordinate bench of this court observed that the submission of the counsel for the petitioner was not proper, as the aforesaid batch of petitions were already disposed of by a coordinate bench of this court, wherein after quashing the impugned resolution as contained in memo number 1845 dated 16/5/2018, the respondent number 2 was directed to look into the aspect on receipt of representation of the petitioners of that case. Undertaking such exercise by the court itself on the request of the counsel for the petitioner will be against the judicial propriety, as in majority of the cases the coordinate bench has thought it proper to relegate such exercise to be undertaken by the respondent number 2. And the Learned Counsel submits that the writ petition was of Rupa Kumari was ultimately disposed of. With the directions contained in paragraph 7 and 8. The Learned Counsel submits that against the said order, LPA was filed. LPA filed हुआ था ना? Passed in the case of Rupa Kumari. LPA was filed or not filed? तभी ना Supreme Court गया या contempt के against the Supreme Court है? Contempt against the said order. When the order was not complied, a petition was filed being contempt case within bracket civil number 1034 of 2023. And
actually उसमें paragraph 7 में जो direction था रूपा कुमारी
exactly. In the said contempt proceeding, the opposite party number क्या बोल रहे हैं? Opposite party number 2, Mr. K. Srinivasan, Secretary Rural Development Department, Government of Jharkhand, assured the court that if the amount of GPF, GIS and third MSCP as well as full pension has not been paid to Rupa Kumari Sinha, the same shall be paid to her. ये 13/6/25 का ऑर्डर है, SLP का 5 है।
ये 11/4/25 के ऑर्डर के बीच में है।
कहाँ है वो ऑर्डर?
ये है।
दिखाइए।
11/4 उसका 9।
एक second. When the order was not complied, the contempt case civil number 1034 of 2023 was filed and an order dated 11/4/2025 was passed, giving last indulgence to the opposite party to comply the order dated 12th of July 2023 passed in WPS number 4792 of 2018 and a notice of contempt and to file a compliance affidavit. It was also directed that let a notice of contempt be issued to the said opposite party number 2 in Form 1 under Rule 393 within bracket Roman 1 of High Court of Jharkhand Rules 2002, for which recusals etc. was to be filed by 16th of April 2025. And the opposite party number 2 was directed to remain physically present before this court on the next day fixed. The Council submits that the order dated 11/4/2025 was challenged by the opposite party number 2 before the Honorable Supreme Court in contempt civil in SLP within bracket C number 13515 of 2025. Where is that order?
Sir.
No, the order has been placed on record. No, the order has been placed before this court, wherein the learned senior advocate appearing for the state of Jharkhand fairly submitted that order will be implemented within a period of 1 month from the date of the order, that is from 9/5/2025, and ultimately it was observed that the High Court may not proceed with the contempt proceedings till that time. The special leave petition was disposed of. Thereafter, the matter was taken up before this court. In the meantime, and when the matter was taken up by this court on 13/6/2025, it was submitted by the opposite party number 2 before this court, before the court in contempt case civil number 1034 of 2023, that if the amount has not been paid to Rupa Kumari Sinha, the same will be paid to her. During the course of hearing, it is an admitted fact that amount has been paid to Rupa Kumari Sinha. However, the learned counsel for the respondent, opposite party, has submitted that the payment has been made by virtue of the order dated 3/6/2025 passed by the Secretary, Rural Development Department, directing for payment, but certain conditions have been imposed therein. Those are A. The amount could be paid from the fund maintained by the district. B. In case the amount will be, the payment will be subject to final decision which may be taken in connection with the services of Rupa Kumari Sinha. C. In case the decision, the ultimate decision is not taken in her favor, then the amount will be recovered at one go from her. And in case the decision is taken in her favor, then the amount will be adjusted. Yeah? That condition?
And Mantri
He has also submitted that the concerned, the order was passed after concurrence of the departmental minister. The records of the case reveal that यहाँ पे शोकॉज पहली बार कब फाइल किए हैं? Supplementary शोकॉज. When was the first शोकॉज filed? पाँच 2/25. ये सप्लीमेंट्री शो कॉज है इसमें. The learned counsel for the opposite party has referred to the show cause dated 18/3/2025 filed by opposite party number 2 in the connected contempt petition being contempt civil number 784 of 2024 and has submitted that the matter regarding granting of status of permanent government employee to the petitioners is to be taken by competent authority, that is the cabinet, and Principal Secretary, Department of Rural Development is not the competent authority, and the matter was pending before the cabinet. The learned counsel has submitted that the matter of cabinet of Rupa Kumari Sinha, along with the present petitioners, totaling 127 persons, is pending before the cabinet for consideration, and the payment made to Rupa Kumari Sinha will be subject to the decision of the cabinet. The learned counsel has submitted that since the opposite party number 2 had given an undertaking before the Honorable Supreme Court in connection with compliance of the order, it was in this light the payment has been made to Rupa Kumari Sinha. And therefore her case stands on a different footing. Correct? To this, the learned counsel for the petitioners has submitted that the case of the of Rupa Kumari Sinha is on identical footing as that of the present petitioners, and it was the order passed in this case, which was followed in the case of Rupa Kumari Sinha. It was the they stand on same footing, and therefore there can be no reason to treat the petitioner differently from that of Rupa Kumari Sinha. The Learned Council has submitted that if similar order is passed in the case of the petitioners, they would be satisfied. Correct?
That is there in the order itself. The reasoned order is to be communicated to the petitioners through the email and all. So a reasoned order has to be passed by.
The Learned Council has submitted that reasoned order has been passed in the case of Rupa Kumari Sinha, but no reasoned order has been passed so far as the present petitioners are concerned.
3/6/25. Reasoned order has been.
Yes, the Learned Council submits that the opposite party number 2 has omitted to pass the reasoned order so far as the petitioners are concerned, only to deprive the petitioners of similar benefits as that of Rupa Kumari Sinha. And therefore,
undertaking was given on 22nd April 2025 before this personally.
he has also submitted that an undertaking was recorded नहीं होगा तो हम नहीं लिखेंगे.
Record.
Order दिखाइए. किस
22nd
record में है?
April.
किस record?
तीनों में एक ही order.
The Learned Council has referred to the order dated 22nd of April 2025, wherein the opposite party number 2 was personally present before this court, and it was submitted that the entire matter will be resolved within a period of 2 months. After hearing the Learned Council's appearing on behalf of the parties and considering the aforesaid facts and circumstances of this case, which has been dictated in open court in presence of the parties, this court finds that a specific direction within a time frame was given to the opposite party number 2 to pass a reasoned order. But the opposite party number 2, on the one hand, has not passed any reasoned order so far as these petitioners are concerned, and so far as Rupa Kumari Sinha is concerned, a reasoned order has been passed extending certain benefit to her, and
By regularizing her services.
by which her services,
conditional order
just her services has been regularized, and
subject to,
and there is a direction for making payment to her, and payment has also been made to her, subject to final decision by
subject to certain conditions that is there.
Yes, subject to the aforesaid conditions as pointed out by the Learned Council for the opposite party.
And
however, no similar benefit has been extended to the petitioner, and the opposite party number 2 has willfully and deliberately not passed any reasoned order so far as the petitioners are concerned. This court is of the considered view that this court is prima facie of the considered view that the petitioner, that the opposite party number 2 has no regards to the orders passed by this court and is giving different treatment to similarly situated persons. It is not in dispute that that case of Rupa Kumari is also similarly placed as that of the petitioners, as her case is also one amongst 127 persons which has been placed before the cabinet. Accordingly, let a notice of content be issued to the opposite party number 2 in Form 1 under Rule 393 within bracket Roman 1 of High Court of Jharkhand Rules 2001, for which requisites etc. must be filed by within a period of 2 weeks from today. The opposite party number 2 it will be open to the opposite party number 2 to engage a separate counsel engage an independent counsel to defend his case before this court. The order dated 3/6/2025 passed in the case of Rupa Kumari by the opposite party number 2 himself, and also the order passed in WPS number 4792 of 2018, and the aforesaid orders passed in the case of WPS number 4792 of 2018 and in contempt civil number 1034 of 2023, and also the orders passed by the Honorable Supreme Court wherein the opposite party number 2 has given, where an undertaking was given by the state of Jharkhand before the Honorable Supreme Court in the case of Rupa Kumari has been extensively placed by the legal counsel for the parties. ठीक है, एक तो डेट दे देते हैं. The opposite party number 2 is directed to remain personally present on the next date at 10:30 a.m. Holds this case on 12th of September.